Hello, my name is W. Bailey Smith. I'm a trust doctor, not a medical doctor. I fix trusts. Some trusts are broken, some trusts are out of date, some trusts need to be created. I specialize in showing families how to keep their family money together for generation after generation by avoiding predators and creditors, by reducing or eliminating the voluntary estate tax, by making sure that the in-laws that become outlaws will not be heirs of the estate. I got into this business a number of years ago because my parents came to me and asked me to join them when they decided to do their own estate plan. And I was working in the district attorney's office at the time. I didn't know anything about estate planning. And after several meetings, my parents signed their documents. We thought everything was in order. Several years went by and they were on a vacation, and unfortunately they were in a plane crash in the Canary Islands. Both my parents died in that plane crash, and suddenly I was confronted with all these estate planning documents that I really didn't understand since I had no experience in estate planning. Unfortunately, my parents had gone to an attorney who was not certified as an estate tax planning specialist. He was what we call a general practice attorney, attempting to do personal injury actions on Monday, criminal actions on Tuesday, real estate transactions on Wednesday, and then estate planning on Thursday. Did not do a very good job. Because of this, I ended up going through probate. It took me 3 years to receive my inheritance, and literally hundreds of thousands of dollars were just thrown out because of unnecessary taxes and probate fees and costs. Since then, I have specialized in estate tax planning. There are 10,000 attorneys in Orange County, all of whom say they're specialists, but less than 0.5% have been certified as estate tax planning specialists by the California Bar Association. I'm one of those certified specialists. I work here at Treadway, Lumstein & Doyle, a law firm of 16 attorneys with offices in Irvine, Long Beach, and Downey. We help families keep their family money together for generation after generation. And today I'm going to be speaking to you on how to plan your estate today. To make this interesting for you, I want to talk about some famous people. I want to talk about John Wayne and Bing Crosby. I'd like to talk about Chief Justice Warren Burger, the Segerstrom family, who have the South Coast Plaza shopping center, one of the biggest shopping centers on the West Coast, to make this whole area of estate planning come alive for you. Now, John Wayne had gone to a prominent firm in Los Angeles, and unfortunately he ended up going through probate because they didn't specialize in estate planning. His probate here in California took over 6 years, and then he had probates in Arizona, Nebraska, and also in the state of Washington. These probates could have all been avoided with proper planning. He could have saved $250,000 in probate fees here in California alone. He could have also saved millions of dollars in taxes by getting proper tax advice. Bing Crosby had been through a similar situation with his first wife. Without proper planning, he ended up having to sell a number of important assets to raise the money to pay the taxes that were due at his first wife's death, including the Del Mar racetrack. And so when Bing Crosby got around to planning his estate properly, he finally ended up setting up a revocable living trust. So today I'll be talking about several different ways to plan your estate. We'll look at the pluses and minuses of each of these opportunities, and we'll concentrate on the idea of the trust. We'll see the trust comes in a number of different forms. There's the revocable living trust, and there's the testamentary trust. There's the irrevocable trust and the revocable trust. There's a funded trust and an unfunded trust. There's a legacy trust, also known as a dynasty trust or a triple generation trust. We'll talk about how important it is to get privacy, to save time, to save money, to avoid the living probate, also known as a conservatorship, to avoid guardianships, to save taxes, because the death tax in America, the estate tax, some people call it the inheritance tax, I simply call it the death tax, is really a voluntary tax. It's a question of what sort of plan you've set up. We talk about who the trustee of your trust should be, what assets should go into the trust, and finally we'll talk about how you hold title to your assets. Some people hold title in joint tenancy, other people in community property, some people as a tenant in common. It's important that you coordinate title with your trust to make sure you have all the benefits of the trust. So first, I'd like to talk about different ways to plan your estate. And I'd like to begin with the most popular ways and then going on down to the more sophisticated ways. By far, the most popular way to plan your estate is what I call the Jerry Brown Special. Jerry Brown, our governor, has a plan for you if you're too busy to plan your estate. This is called the intestate statute. This is for people who have no trust, no will. The Jerry Brown Special is the most expensive way to plan your estate because you end up going to probate, you're facing a potential guardianship, conservatorship, and paying unnecessary death taxes. But that's the plan you've decided upon because you're too busy to plan a proper estate. Next most popular way of planning your estate is the do-it-yourself plan. LegalZoom is well known for planning people's estates without lawyers. It's a self-help plan. Lawyers not involved. California is one of 17 jurisdictions that allows you to plan your own estate. You don't need a lawyer to write a will or to write a trust. You can do it yourself. The problem with LegalZoom is the results are very similar to option number one, the Jerry Brown Special, which is the intestate plan. Chief Justice Warren Burger, the Chief Justice of the United States Supreme Court, was a brilliant corporate attorney, a fine attorney who knew nothing about estate planning and decided to write his own plan. He saved about $4,000, but his plan resulted in a probate and unnecessary taxes that cost his family approximately $400,000. Opportunity number three in planning your estate is the I love you will. I love my spouse, everything to her, otherwise down to the children. Now these first three types of plans, the Jerry Brown Special, LegalZoom, and the I love you will, are not the best ways to plan your estate, in my opinion, because the costs of probate, the delays of probate, having to go to court for guardianships, conservatorships, and having to pay taxes that could have been reduced or totally eliminated. The next four ways of planning your estate are better ways to plan. The testamentary trust is a type of trust that's contained in your last will and testament and then springs up out of the last will and testament. The testamentary trust is good in the sense it saves taxes, but it's bad in the sense because it's contained in your last will and testament, you have to go to court. The next option is the simple revocable living trust. This is great for somebody who doesn't have to be concerned about taxes, perhaps has $1 million worth of assets, wants to avoid the death probate and the living probate, and can save about $50,000 in probate fees by setting up a simple revocable living trust. The next example, the AB trust, or the ABC trust, if you decide to implement the anti-Gigolo, anti-Floozy provisions, is an opportunity for you to not only avoid probate, but also save hundreds of thousands of dollars for your family by avoiding the voluntary estate tax. Under the AB or the ABC plan, sometimes known as the standard trust, the assets of the death of the first spouse go to the surviving spouse, and usually the plan splits into two parts, the A share and the B share. A stands for above ground, that's the survivor share. B stands for below ground, that's the decedent share. The surviving spouse has the use of all the money during her lifetime, and then in her latter passing, the estate is given out to the children, usually at staggered times, maybe a third at 30, half at 35, the balance at 40. The assets go outright to the children. It's been my experience when children receive this money, they often lose it because of that unfortunate divorce, or because of a car accident or a lawsuit or bankruptcy. A better opportunity, I feel, is to continue the assets for the benefit of the children in an ongoing trust. This is the legacy trust, opportunity number 7. The dynasty trust, also called the triple generation trust. And under this plan, when one of you dies, it all goes to the survivor, tax-free, and then after the death of both of you, your family trust continues for the benefit of your children. Just imagine your children getting their money in a cookie jar, and each of the children can be the trustee of their own cookie jar. They can reach in and get the income, they can get the principal, but by giving it to them in this ongoing legacy trust, you avoid the in-laws that become the outlaws because you keep the money as the child's sole and separate property. It will not be commingled as community property. You can avoid or reduce creditors or predators from getting at this money because the ongoing trust owns the money. So it's a beautiful way to give asset protection, predator protection for your children. And then they can leave it on down to your grandchildren in an ongoing trust as well. Here in California, we can continue these trusts for 90 years to make sure your family money stays in the family bloodline. How would you feel if your children did not end up with your estate? How would you feel if your grandchildren did not receive their estate? You have an opportunity to make sure that it ends up in the hands of your children and grandchildren. Now, the idea of the trust is one that's been around for a long time. We got the idea from England. This is nothing new. One of the reasons people think in terms of setting up the trust is for privacy. If you have a business, you certainly want to keep things private. You don't want everybody in the world to know the details of your business, so the trust gives you that privacy. Also, the trust saves time because the minimum amount of time in probate with the simplest estates are a year. John Wayne's estate took over 6 years. Marilyn Monroe's estate took 30 years. If you can avoid the court and save time, in my opinion, it makes sense. Also, you can avoid the problem of guardianship. This is the story of the prodigal son from the Gospel of St. Matthew. Don't give money prematurely to your children. If you leave money to children outright, and if they're under the age of 18, the court steps in and grabs the money and puts it in a legal proceeding, much like a probate, where the court's in charge. And there are ongoing fees and costs and bonding expenses. A better way to leave the money is to select somebody that you have faith in to manage the money for the benefit of that child or grandchild and avoid court proceedings. In a guardianship, the court gives the money outright to the child at the age of 18, which I think is the wrong time to give money to children. It's been my experience that children under the age of 30 think they know everything, but in reality they don't know much, certainly when it comes to assets and managing property. Sometime in their 30s they develop some economic sense, and at that time is the best time to allow them to manage the money and get at the money. Also, we're all getting older. It's important to avoid this thing called the living probate or the conservatorship. This is what happened to Groucho Marx. He did not do a very good job planning his estate, and he ended up in an expensive proceeding called a conservatorship, which is very similar to a probate that happens while you're alive during your period of incapacity. The judge gets involved, the judge appoints somebody else to step in and manage your estate. Everything is public, it's messy, there are ongoing accounting fees, bonding fees, and it's best to be avoided. When we think in terms of setting up a trust, of course, we not only create the trust, but we also have ancillary documents. You'd want to have a current healthcare directive, an advanced healthcare directive with HIPAA regulations in there, allowing the doctors to talk to the agent that you want to have step in and make healthcare decisions for you in advance. If you don't have a current HIPAA language in your healthcare directive, the doctor can't even talk to your spouse or to a child about your healthcare decisions because he can be fined $250,000 or could lose his license. So it's important that you have a current advanced healthcare directive to avoid the Terry Schiavo mess the young gal in Florida who did not have a written document, and they ended up in keeping her alive artificially for 13 years, even though she had been brain dead for the last 12. Another document that's important to have is a durable power of attorney. That you appoint somebody, usually your spouse or somebody else in your family, who will step in and sign your checks, pay your bills for you during your period of incapacity. This allows you to avoid the conservatorship. And then, of course, you'd have wills in coordination with the trust. And the wills would simply pick up things you had forgotten about and put it into the trust. By way of illustration, if this is your trust and this is your will, and not all the assets are in the trust, the will pours those assets into the trust. We sometimes call this a spillover or pour-over will. That's an important thing to have as well. And then it's important to keep your trust current. When was the last time you sat down with your attorney and reviewed the assets in the trust? I'm constantly reviewing trust and finding clients have forgotten to update their documents. They don't have current health care directives. The durable power for property only lasts for 5 years. You need to have that updated to avoid a conservatorship. It's important that you meet with your attorney on a regular basis to make sure all the assets are in the trust. By way of illustration, a trust is nothing more than a container for your assets. It's important that you have the major assets in the trust. And I imagine, like most people, your biggest asset is your home. We want to change title from joint tenancy to the trustees of the trust and make the house part of the trust as community property. Take advantage of the double step-up value and basis. We want to make sure the house goes into the trust. There's no increase in property taxes by putting the house in the trust. And then you may have some other real estate. You could have a little commercial building. The same thing here. We want to break the joint tenancy, take title in both your names as trustees for the trust, and make it community property. You may have some savings accounts, CDs, money market accounts. You want to get these into the trust as well by going down to the bank and changing title to these accounts to your names as trustees. And I know some of you are involved in the stock market. Here are a couple of my favorite stocks. They always pay good dividends. You want to have your financial planner, your stockbroker, change title to these stocks and bonds and get these into your trust as well. If you've sold real estate, perhaps you're taking back paper on that real estate. Trustees, we got to do the transfer of those trustees into the trust. All major assets go into the trust. Even your personal effects, furniture, and furnishings. Certain assets will not go into the trust. We usually don't put cars in the trust because there's no probate on cars and people buy and sell cars every few years. If you want to put your cars in the trust, you may, but there's no need. IRAs, KEOs, pension profit sharing plans do not go into the trust. The primary beneficiary should be your spouse. Secondary beneficiary should be your children as a general rule. Annuities passed by contract, they normally stay outside the trust as well. Now later on, if you decide to refinance one of these pieces of property, the banker may ask you to take the asset out of the trust to refinance that. If that's the case, make sure the banker also puts it back into the trust, otherwise you'll have a probate later on. It's important that all the assets get into the trust. I recently had a client here in Newport Beach who I hadn't seen for a number of years. I encouraged him to come in to sit down with me and review all the documents to make sure everything was current. And he did not come in time. He died at 90 with a trust I had done for him 25 years ago. And because of that, we discovered after his death that he had missed 25,000 shares of stock that cost a probate. So it's important that you keep everything current and all the assets are in the trust to avoid guardianships, living probates, and death time probates. Who's the trustee of the trust? You should be the trustee of your own trust. If you're married, you and your spouse. If something happens to one of you, the surviving spouse alone. Otherwise, who do you want to have step in? If your children are mature enough to do it, that's ideal. If not, your brother, your sister, a bank, a trust company, whoever you have faith in, that's entirely up to you. In terms of how you take title to the assets, many people hold title to appreciating assets in joint tenancy. that is the wrong way to hold title. The reason being is that you've got income taxes you'd have to pay after the death of the spouse that you could otherwise avoid if you change title from joint tenancy to community property. Let's say you have some stock that you bought a long time ago for $50,000, and now that stock has gone up to $250,000. If you sold that stock while you're both alive, what would be your exposure to long-term capital gains? The difference between your cost and the fair market value, $50,000, $250,000, $200,000 would be exposed to long-term capital gains. And the new rate this year is approximately 24%. However, if you held on to that stock until one of you died, the tax would be dependent on how you held title. If you held title in joint tenancy, the decedent's share would be stepped up, but not the survivor's share. And so then you'd have approximate tax based on the difference between the two of $100,000. However, there's not only a partial step-up value and basis for the decedent's share, but also for the survivor's share, so the surviving spouse can then sell that stock and avoid the long-term capital gains tax completely. So it's important that appreciating assets be held in the trust as community property, take advantage of this double step-up value and basis. There are other more sophisticated techniques you can use too. If you have real estate or if you have businesses, we recommend clients have LLCs like the Segerstrom family in South Coast Plaza. They set that up not just for asset protection, but also to fragment their assets between themselves, the children, the grandchildren, to get substantial tax savings and passing their estate on down to the next generation. Roy Rogers, the king of the cowboys, set up a family limited partnership to save taxes and transferring his assets down to his children as well. Jacqueline Kennedy Onassis set up a charitable trust to benefit both charity and her children and to save millions of dollars in taxes. It pays to be charitable today. So these are various legal loopholes that you can incorporate into your own plan to avoid taxes. Now, the current federal estate tax exemption as of January 1st, 2013 was set at $5,250,000. The tax for assets above that is 40%. That was permanent. What does permanent mean? It means for this Congress only. Because last week, President Obama, in the Green Book, which is his proposed tax policy, proposes to reduce the federal estate tax exemption from $5,250,000 back down to $3.5 million, and to increase the death tax rate from 40% to 45%. Mark Twain told us over 100 years ago, there's not a more dangerous time for the American public than when Congress meets. And it certainly seems so. So today we've been talking about different ways to plan your estate. If you'd like to learn more about this, please call my office. I have a 50-page booklet I wrote in plain English talking about how to plan your estate, talking about various legal loopholes. Today we've been talking about John Wayne because he did not do a very good job of planning his estate and ended up in probate, also ended up paying unnecessary taxes that could have been reduced or totally eliminated. We know Bing Crosby did a better job by saving taxes and staying out of court and planning his estate. We've seen there's several different ways to plan your estate. We know those most popular ways of planning your estate will cause taxes, probates, potential guardianships, and conservatorships. The Jerry Brown Special, the legal loophole plan, I should say the LegalZoom plan, also the I Love You Will. These first three arrangements are not the best ways of planning your estate. We looked at more sophisticated ways of planning your estate, the testamentary trust, the simple probate avoidance trust, the AB standard revocable living trust, and the legacy trust, also known as the dynasty trust, which to me is the biggest legal loophole in the tax law, because it acts as a prenuptial agreement for your children when they get married to make sure that the assets you have in the family go just to your children and then down to the grandchildren. It will not go out to the in-laws. It gives unbelievable creditor protection for your family as well. I hope you've enjoyed this brief conversation on estate planning, and if you have any further questions, I'm happy to meet with you either in the Irvine office or in the Long Beach office of Treadway, Lumstein, and Doyle. Thank you very much.